Hi, all the audience here. My name is Chin Chui Lee. My metric ID is 920210025030001. Today's course subject I'm going to present here is Innovation and Technology Management. Introduction: Intellectual property, creation of mind, invention, literary and artistic work, design and symbol, name and image used in commercial are all examples of intellectual property creation. This following slide is what myself going to share to everyone here today, which is first, opinion on how intellectual property can help or hinder innovation. Second, type of intellectual property. Third, case study regarding its intellectual properties, relevant, example and case. Fourth, conclusion for overall. As I told before, intellectual property is a key aspect for economy development. First, opinion on how intellectual property can help or hinder innovation. Help. IP provide the incentive that enable innovators across a wide variety of industries to undertake the often risky, difficult, expensive, and time-consuming process of creating new-to-the-world innovations. IP is just as important for startup because it generates capital and revenue, enabling companies large and small to invest in researching, developing, manufacturing, and marketing their product. Second, type of the intellectual property. There are four types of the intellectual properties as I stated here: copyright, patent, trademark, and trade secret. Copyright is a legal means of protecting an author work. It is a type of intellectual property that provide exclusive publication, distribution, and usage right for the author. There are many types of the content can be protected by copyright. Example include books, film, plays, songs, film, and artwork. In current modern time, copyright protection has been extended to the website and other online content. The duration of the period for which a copyright is valid differ depending on the law of the country in which copyright is granted. Example, for Malaysia, should any work which is copyrighted in Malaysia be designed, curated, or written jointly, the copyright will be effect until the date of author or creator. The artwork will be protected until 15 years of date of all author or creator. And here, patent. A patent refers to an exclusive right granted by the government to the owner of an invention which gives him limited monopoly right for his new invention in exchange for full disclosure of his invention to the public. The patents system benefit to the public through the increased technical knowledge which is generated by the disclosure of an invention and concurrently benefit the inventor through the exclusive right given over his invention for a period of a time. Her Patent Act 1983 and the Patent Regulation 1986 are two sets of law that govern the patent since in Malaysia. The duration of the patent should be 20 years from the filing date of the application, subject to the timely payment of the prescribed annual fees. However, Where a patent application was filed before 1st August 2001 uh, and was pending on the date, the duration of the patent granted on that application should be 20 years from the date of filing or 15 years from the date of grant, whichever longer. Trademark is essentially a form of identity used by the trade and or the present a company or product in the course of trading. It is used to distinguish one product from another by way of the recognizable sign, design, and expression to identify a product or service. Trademark in Malaysia. Trademark Act 1976. The registration will be valid for 10 years. The filing date will be the date of the registration. Trade secret. Intellectual property right on confidential information which may be licensed or sold. Second, research and engineering data, engineering drawing, process sheet, computer, software code. In Malaysia, the term trade secret is interchangeable with confidential information with the latter term recognized official in Malaysia law. Trade secrets are not eligible to be registered in Malaysia. However, one can be legal action against others should their trade secret be exploited. Registered design protect only the appearance of the product. For example, the look of the computer monitor. Design can be registered in Malaysia government by Industrial Design Act 1996. Open grant, the protection of the design will be for 5 years calculated from the filing date and is extendable for 2 consecutive terms of 5 years. Case study. In the case of the Alpha Home Appliance Sdn Berhad versus NSB Home Appliance and NSB Lighting Sdn Berhad, the High Court allowed the plaintiff claim and the defendant of counterclaim is dismissed with the cause. By way of background, Alpha Home Appliance Sdn Berhad referred as a plaintiff as company incorporated in Malaysia and deal with the research and development, manufacture and distribution of home appliance, in particular to the fan and water heater. NSB Home Appliance is company incorporated in Malaysia and its business included the manufacture, import, export and distribute all kind of the home appliance, and NSB Lighting Sdn Berhad is referred to second defendant nature of business to trading in electrical lighting fitting. Conclusion. Intellectual property can serve as a strategic resource for organization. Intellectual property protection is critical to fostering innovation. Without protection of idea, business and individual will not reap the full benefit of their invention and will focus less on research and development. And third bullet, artists will be not fully compensated for their creation and cultural vitality will suffer as a result. Last not least, I would like to end my presentation by thanking all the frontliners for their sacrifice they went through during the pandemic period. Thank you, everyone.